So it's called to order the Village of Riverside Planning and Zoning Commission regular meeting of Wednesday, March 23rd, 2022. Please call the roll.
Commissioner Marhol,
Here.
Commissioner Miller,
Here.
Commissioner Pelletier,
Here.
Commissioner Brahm,
Here.
Commissioner Matthews, and Chairperson Mateo.
I'm here. We have a quorum. Is there a motion to approve the minutes of the Planning and Zoning Commission's special meeting minutes of February 28th, 2022?
I move to approve.
Okay. Is there a
Second.
second? Any edits?
I have edits in 2 areas.
I'll let you go first then.
Okay. So the first area is about the middle of page 4 in the printout, where we were talking about the Todd, and there were 2 subjects that I thought should be added to our discussion that weren't covered in the narrative. One of them, and this is just as I recall, I didn't review the video of this part, was that I had pointed out how, and we had then subsequently had a discussion about how similar the B1 Todd as defined was to the B1C in its uses, with the whole discussion of the ground floor dwellings being allowed and whether that was consistent with this transit-oriented development. And again, just comparing how the B1C and the B1 Todd didn't seem to be differentiated. And then also, during that discussion, I had raised the issue about the whole special use standard that Riverside had, and whether, for instance, if we didn't want to have an office in a ground floor and it's designated as special use, was there any way we could actually functionally apply the special uses? So I think those 2 subjects should be included in the minutes. And then on page 5, in the first paragraph, where there was the discussion about the fence at 40 Kimbark, I did review this part of the video, and it starts at about hour 2 minute 30 seconds. It says, Commissioner Hennigan asked if, without a variation, the petitioner would be able to build a 6-foot privacy fence. And so from that point on, I would suggest some edits, which is, would be able to build a fence, because there was no mention of 6-foot or this word privacy in that discussion, from the southeast corner of the house going straight to the garage. She commented that the proposed fence is then just 5 feet out from a fence that would be allowed by code. And then the last sentence in that paragraph, it says, Village Planner Jimenez and Chairperson Mateo both stated that by right, I would take out the privacy and put in a fence, and then take out would be and put in is allowed, take out with no variation, and put in a rear yard, but not in a street yard, period. And then I would also add, Commissioner Marhul commented that essentially the variation proposal is to move the fence that would be allowed under code 5 feet further south and beginning at a point that allows the side door to be captured. So those are my edits. I think that's a better description for people reviewing.
Your discussion on the first part, you were suggesting information be added. Is that, did you have it written down as a suggested edit? Or
I
is that
didn't. I
something
could
that-
write something up, but I
Well,
didn't
what-
review the video. You mean in the Todd discussion?
Yeah.
I could write something up if you want, but I didn't.
Well, not necessarily. I just, if we still have information to add, I would suggest that we just hold these off and make these amendments and pass out revised minutes at the next meeting and approve them then, if that's okay with everybody. So we have a complete document in front of us.
We know what we're agreeing to. Any other edits? I have one, Francisco, on the top of page 3 of your memo. It says, hearing, period, Commissioner Hennigan.
Okay.
You see where I am? Commissioner Hennigan made the motion and Commissioner Marhol seconded it.
Yeah, it's just top, page 3 of the minutes.
Oh, the minutes. Oh, I don't have the minutes, but I can write it down.
Oh.
Sorry.
If we could just add there that Commissioner Hennigan made a motion to close the hearing,
Okay.
please. So we have seconds. We need to table or continue to the next meeting?
Yes, so we have a motion and a second already?
Mm-hmm.
Yeah, if we could just have that motion withdrawn and a new motion, or we don't even need a motion. If we just withdraw the motion, and then we'll just put it back on the agenda for the next meeting.
Commissioner
So
Braun,
I
you
would
willing?
withdraw it. I withdraw my motion to approve the minutes of February 28th, 2022.
And then if, for the record, I could just address the fact that Commissioner Matthews is participating remotely this evening. He is under the weather, and that's one of the reasons for which you are authorized to participate remotely under the Open Meetings Act. Commissioner Matthews, are you there?
I am here.
Okay, does everyone recognize that as Commissioner Matthews' voice?
Yes. I do.
Yes.
Very well. John, if you have any issues hearing during the meeting, please let us know.
Sure, thank you.
And I had you written down right after the roll call. Do we have any visitors that want to speak? Hearing none. A liaison report for the village board?
Okay, at the previous board meeting, the Board of Trustees reviewed the recommendation for approval for the deck at 490 Uvedale, which was allowing a non-conforming structure to be built at 5 feet from grade and also expanded. The board approved that recommendation. They didn't have any concerns or issues and were glad that the existing deck was going to be replaced and repaired with something new and with materials that were more durable, and the fact that the deck would also be up to code. They denied the recommendation for 40 Kimbar, excuse me. The board denied the variation for the fence on the corner lot. There were, the petitioner came to the board meeting with a fence proposal, but the material was to be wood. There were some concerns by the board. I believe Trustee Pollock wanted a fence that was, I believe it was aluminum, a black aluminum fence, but the petitioner was having difficulties with obtaining that material and submitted an elevation that was, it was a wooden fence. The board denied that. And the petitioner, I believe it was the day after, submitted a permit for a 6-foot privacy fence from the southeast corner of the house, going straight back to the garage, and on the north end of the property there, 3 feet from the property line, because there's a fence there currently. So he did come to Village Hall on Friday afternoon with that proposal. There is also going to be an update to the application for variations for the village. We're going to try to make the application a little bit clearer, a little more thorough, and also have, for applicants, a better understanding of the timeline, so they kind of get a sense of how it goes through the village Riverside, so they have a realistic kind of expectation and understanding of that timeline. And it also allows staff to research and prepare, and allows the petitioners to better prepare themselves as well for any public hearing or speaking in front of the board. And we are also finalizing a redlining draft on accessory structures and uses. So we have been working with Trustee Pollock with that to get a version of that on the board agenda, which will then come back to Planning and Zoning for public hearing and review to make sure that the language that is being used is what Planning and Zoning thinks is appropriate. Did I miss anything?
No.
Okay.
Thank you. So we see those filled out applications in our packets. If you want to take a look at it, see if there's any suggestions that you want to make to staff for improvements, either for the petitioners or for us, please do so. Next up is old business. Oh, Attorney Mars, you wanted to make a few comments?
Oh, just as we start this item, you know, you guys have been going through these consultant recommendations on the TOD and the sign code, et cetera, with an eye towards upcoming public hearings for text amendments to enact all that. You know, part of the positive of going through these a couple times in advance, because it's, you know, discussed in good detail between you guys, is that hopefully by the time we get to the public hearing, we have a pretty good consensus on what this language should be, so that at the public hearing, you know, it's an opportunity for the public to provide their input at that time on the record. But in terms of you guys, our hope from staff, and Ashley and I were talking about this today, is that generally everyone feels good about the changes, and we're not in a situation where we're kind of dissecting these provisions and making a lot of changes on the fly, or having a number of votes because there's disagreement over how these things should read. So I guess I wanted to say, and I know you guys have been doing this for a few meetings now, but as we go through this language, you know, if there's anything that you individually aren't comfortable with in terms of thinking, well, I don't know if I could support that when we get to the public hearing, or I think that should be worded differently, let's, you know, bring that up, and we'll try to work through it so that we have kind of a consensus on how we would like it to read for the public hearing.
Okay, thank you.
Oh, and also, as we remember for the standards, you know, for standards for text amendments, it's not like the variations and special uses where we have this defined set that you have to meet every single one of these. We have a group of standards, and those will be in your report next time. And you kind of say, well, you know, does this one apply, and this one apply, and this one apply, and ultimately this is in the best interest of the village to enact these text amendments. And so the other aspect of this at the public hearing is, you know, if we have a general consensus on what the language is saying, and we go through it and we get the public comment and everybody feels good about it, it's our hope that we can just kind of go through the standards once as they apply to all the different aspects of it, and talk about, well, this standard, you know, is met because of this aspect and that aspect, so that we're not making findings, you know, on each little subsection. So keep that in mind also.
So in general, we'd find that for all of the changes, or by
Yeah, so
section, the way Ashley has kind of sectioned things?
right, you guys can handle it however you want, but you don't have to find it for each section. I mean, because there's some overarching themes here in terms of, you know, transit-oriented development, or getting rid of the content-based language and all that kind of stuff. So you can kind of say, well, this standard, you know, by getting rid of the content-based language, this standard is met, and by encouraging bicycle and pedestrian use, you know, we find this standard is met. And kind of overall, we're just kind of matching up some of the themes with the standards and deciding whether overall it's in the best interest of the village. That's one way you could do it.
Okay, overall, okay, all right. And then, do we go through all those standards a second time at any point, once the board has approved things, or after the public hearing, or is there just one opportunity for us to find the standards for the text amendment?
So at the public hearing, we'll, you know, probably we'll have the consultant here. We talked about that,
Yeah.
kind of giving an overview of the changes and the reasoning behind them. Then our opportunity for public comment. And then if you guys are comfortable, you know, you can start looking at it. You can do whatever. You could go through a page at a time if you want, again, and make sure everybody's good with everything.
Well, I guess I was just asking, so we'd only necessarily have to do that a second time if there were changes based on public comment, or on what the trustees
Correct.
have changed
Right.
after our initial
Right.
recommendation.
And another thing to keep in mind along those lines is, you know, if you guys get into discussion and decide, well, there's 3 or 4 things that we would like to change, and in order for us to feel better ultimately about this, it's no problem to continue it while those amendments are made, and you know, kind of delay your findings on the standards till you have the revised document before you that you feel good about. So you have a lot of options, but I was just trying to give a kind of a roadmap as to how it might be most efficient to look at all this.
Well, the anticipation, if I recall correctly, is to have at least 2 public hearings, one in April and one in May.
Right.
On different sections of the proposed changes.
Right.
So at April's meeting, we can't really say, well, let's wait until the May meeting to vote on the April substance, because they will have different public notices, correct?
Well, you could continue the April consideration to May, and then that would be under continued public hearing, old business essentially, and you could, look at the revised document, make your findings then, and then you open your public hearing on the next section that you're dealing with. So we're going to break them up into 2 or 3 sections, so there's probably 2 or 3 times you'll make findings on different pieces of it, and we'll try to keep them logically. Like, if the TOD is a lot different than signs, so you're not going to make one set of findings for all that stuff. But the sign section is broken up into like 6 different pieces, and you don't have to make findings on each of those 6. You can do it as a
Okay,
the
right, that makes
overarching.
sense. I mean, cohesively,
Yeah.
group, subject matter groups.
right. And we'll talk more about that when we have the actual document and starting the public hearing. But I just kind of wanted to put that in your minds, especially the part about trying to reach a consensus on the language.
Thank you. So now we can continue discussion on the TOD zoning update, please.
All right, well, thank you very much. So for those following along at home, at the February 28th, 2022 meeting, the members here reviewed proposed text amendments for our sign code, as was described, a related code section 1057D5, which is talking about storefront window displays, and also discussed a proposed establishment of a transit-oriented development business district along Harlem Avenue. So it would kind of create an overlay through existing B1 and B1 kind of business district existing there with a different set of standards. So there was discussion then, and it's brought us to this evening. What we're talking about this evening relates predominantly in the realm of establishing that the purpose and intent of the zoning code definitions read as you believe they should. There's a discussion about administration, so just again, kind of those general standards and approach to the zoning code and its application. We're talking about residential districts and some bulk regulations there, site development standards, landscaping and screening, nonconformities, and then kind of the review of definitions and appendices. A lot of the very specific business district-related items, specifically because it does relate back to more of that discussion we were having on the establishment of the TOD district, I felt was related, and if we were going to revisit that conversation, it made sense to group those business district kind of questions, because there's quite a bit more change in that section. So this is wrapping a lot of those residential kinds of questions into the discussion this evening. I'm not going to read everything, the additions line by line as we had prior. I'll just introduce each section of the text and allow the commission members to discuss and provide any guidance for changes or questions that you might have. So without further ado, we'll start with the purpose and intent of the zoning code. And so here staff is just asking the commissioners to consider whether you agree that the phrasing of the zoning code purpose and intent meets the goal of the project and that it is consistent with other zoning principles and practices of Riverside. So that's page 10 in the full packet, 3 of a paper copy memo, so you can follow along. Section 10.1.2.
I have a comment on the suggested change that I'm not comfortable with this specific reference to adhering to complete streets principles. I mean, I don't like that idea of referring to some contemporary idea that could change in 10 or 15 years, and people would be like, I have no idea what complete streets means. So I would suggest using some kind of language that describes what complete streets is about, as opposed to using that title.
Okay.
What do the rest of you think?
We do define that later on, complete streets.
Right, and then how was it defined again? I'm thinking that the definition later on, it might run into the same kind of problem where it's like referring to, guidances that exist right now in 2022, and what if those don't exist in 2032? Or what if they're different and Riverside doesn't necessarily agree with what they say in 2032?
So the definition is a transportation policy and design approach that requires streets to be planned, designed, operated, and maintained to enable safe, convenient, and comfortable travel and access for all anticipated roadway users, regardless of their age, abilities, or mode of travel. So I don't think that's going to change very much, and the code could be
Is that definition in the packet of materials? What page would that definition be?
I have 2 PDFs open. I'm working on the consultant's version 3, so I don't believe it's in our current packet.
It is, okay.
I think it is.
I'm looking at Ashley.
I thought,
I didn't see it in my review of the materials, and I did question complete streets as well. It was capitalized. I figured it was defined somewhere.
It's in 10.11.3, uses defined. Is that in our packet?
I believe that section 11, was added as an attached part of the packet.
It has page 139 at the bottom. When they get into the sideways pages later in the PDF.
I actually obtained the package from the website, and I've got 95 pages.
Okay.
So Commissioner
I could
Braun-
look
Yes.
into that later.
So
It's
you
page
will
45
find it,
of the
yes.
Page
on-
45. It would just be helpful for me to look at that language.
yeah, page 45 of the PDF.
Correct.
That was emailed, I think, is what I have. Isn't complete streets also a state law? Is there state law addressing complete streets at this time?
Not that I'm aware of. There could be,
Okay.
but
I couldn't speak on the state of a law within Illinois, but I do recognize that it's quite common in, municipalities to adopt a complete streets ordinance of some kind that would specifically designate these types of principles being adopted throughout their design and development standards. So, no matter what state I've been in, that's been pretty common. And so I would say that, it's possible if there's any concern that, complete streets in phrasing on its own is not sufficiently, provide enough guidance. If there's a way to briefly summarize that intent or principle in that section.
No, sorry,
Yeah.
the fact that it is noted in the definitions portion of the document with that language should be sufficient. And you can't go to an outside document and say, that's what it is when it's right here. This is the definition. There's no it's not floating or malleable once it's here.
I agree with Commissioner Marhol, excuse me. As long as it's defined within the document itself, and it's capitalized, it's obviously a definition that's defined, I'm okay with just saying complete streets as well. as long as everyone's okay with that definition of what complete streets
So
is.
one of the things that maybe this is getting into too great detail, but I assume that Complete Streets has a lot of things that people should be doing, that municipalities should be doing on their streets, like having bicycle lanes that have certain designations or colors or things like that, and other types of things. And so I know this is only a purpose and intent clause, but I guess I'm a little bit worried that it could be constraining the village in some of its choices by referencing this set of guidances that is being created by someone else, some other agencies. That's all.
I don't
That's my-
think so, because it simply, it says, requires streets to be planned, designed, operated, and maintained to enable safe, convenient, and comfortable travel. It doesn't mention any kind of outside design requirements that would then apply to
And
it.
then it says parentheses, source.
That's
how the
just the source of
metropolitan-
the definition. That's not, that doesn't say.
If that's all it is, and
Yeah.
it's not source, this is the packet of things that a village should be following whenever it repaves its streets, then I'm fine with that. My concern is just constraining the village too much, that's all.
Attorney Morris?
Yeah, I just wanted to point out from a legal interpretation perspective, I mean, the original language of to lessen or avoid congestion in public streets remains the main purpose and intent. The complete streets is just added as an including aspect, so I don't think we would be bound to it by any means. The overarching intent and purpose is still to lessen or avoid congestion in public streets.
Yes, you could be totally right, and it does say principles, it doesn't say following this document. I just wanted to raise my concern about, again, the village being constrained.
I think we're okay on that point.
Would you feel more comfortable if we take out the source language and just leave the definition?
I don't know, maybe, possibly, or saying, I don't know.
Well, what if it's said, instead of saying in purpose and intent adhering to complete streets, how about guided by complete streets? Is that?
That would be
Less-
better, I think, something like that, softer language like that.
Others?
It's fine.
Okay. Anything else in this section?
Oh. Can I say something about the? Of
course.
The next change further down in, was that I?
Yes.
Just so it's clear that employment generating uses is, part of commercial and not its own standalone type of use. I thought we could add the word uses after residential as well. So it says commercial employment generating uses, comma, residential uses, and other uses.
Sure, sounds good to me.
Yeah, good one. Okay, administration.
Okay, so in administration, which is page 12 of the packet, page 11 of the packet, and page 4 of my memo, talks about the kind of a universal change through the document. The idea is to modify the code language to be more current and provide, for example, gender-neutral pronouns, so not him or her, it's just non-gender specific language in the code. There would also be this, over and over based on the intent of what we're trying to incorporate in the code, the language kind of throughout emphasizes the safe access and mobility for pedestrians, bicyclists, and transit riders. So you'll see that kind of over and over throughout different sections of the code, and to make sure that that is the phrasing that you would like to see, and so that's where administration, kind of our notes on that section pertain to. Any comments there?
I have one that maybe you might might want to speak to Manager Francis about. At the very beginning, zoning administrator, the director of community development shall be considered the zoning administrator. Between the two of you, if you want to make it a change to that. It has nothing to do with zoning, it's just staff issue.
Oh. So you're saying that it would not be referred to a specific director? I'm sorry, Chairperson Mateo, I'm not following your.
Well, you
Comment.
are the zoning administrator
Yes.
now, as the assistant village manager. We don't have a director of community development, so do we want to tweak that? And again, this is for staff to talk about, not us.
Yeah, that is actually something that we were trying to determine at one point or another. You'd asked me who that person is.
Right.
There is additional language in other parts of our municipal code that refer to
Okay.
the assistant village manager or their designee being the zoning administrator.
Perfect.
And so it also refers to places where there had been mention of a community development director, and then in that place, the assistant village manager would be acting in that capacity. So there
taken
may
care of.
be a sufficient crossover, but it's not clear based on the language that's included here. So I see your point. We can decide on that. Okay.
And that doesn't have to go with our zoning code update. It could be something to talk about when we're done.
Okay.
In the global substitution issue, the first thing that caught my eye is, why is this in here when we're supposed to be talking about transit-oriented development? It seems like something that goes well beyond that and imposes a burden on staff, basically, to go through the code and do this global change. So number one, I thought it wasn't necessary at all. In this particular 10-2-1-6-C, it actually does seem appropriate to say, or their designees with an S on the end, because we're talking about the director of community development, the village manager, or their designees. But in general, if we want to do global kind of replacements or one-by-one replacements of every time when his or her is referenced, I think a better way to do that is to just get rid of the pronoun altogether. So for instance, here, you could just say, or designees, or designee, and get rid of the pronoun totally. I think that's a cleaner way to do it if the board determines that this is really something that's necessary to tackle at this point in time.
I don't think there are many examples of this change, and elsewhere in the code, I know there's been a movement to get away from, all staff being his, because that's not the case anymore. So it's just, in general, throughout all of our code, that's been the trend, is to be neutral.
But does that mean that someone has to go comb through the code and find it? I mean, or should we just be making that change every time a change is made to the code and not sort of wrap it into this?
Again, in this chapter, I don't think there are that many.
Okay. I didn't notice it in the rest of the red line document of any other places that they had highlighted it. They just said this should be a global change. I don't know how to go about that easily for staff. So it seems like make work to me a little bit.
I think there's a general awareness and sensitivity to that, to the use of particular pronouns, and so I believe that it will be generally more common unless there's a specific purpose for keeping something gendered, that it would, for instance, like if there's a state statute that requires something based upon that, then you'd hold to that. But again, it seems to be a pattern that's pretty common throughout municipal changes, so we would just be aware of that as we made other recommendations. Okay.
Anything else?
I just wonder what the difference is between transit users and pedestrians, bicyclists, and motorists. Are they not included in that group? And I just wasn't sure what the need was to call them out separately.
Well, commonly, I would say that transit specifically, when we typically refer to that as like a bus user, and so there is a point in time where they're inside of a vehicle or riding a bike or put walking to a bus stop or to and from, but specifically when it comes to development, there are opportunities to make it easier for people who are there specifically for the purpose of taking transit to get on that mode. I don't know if that's answering your question, Commissioner Pelletier, but maybe you can clarify if if I'm misunderstanding your question. Please let me know.
I guess I just feel like transit users are probably one of those three things. Those.
Okay.
Unless they're in the mode of transit, of public transit.
The only
Then
way.
they're not a pedestrian or a bicyclist or a motorist, they're a rider in a transit mode of but I agree, I'm not sure, I did not look through this whole thing to see, is transit rider always referenced in the right place? Because I really not do that kind of.
Does it have to do more with the path of access from the bus stop or train stop to the property in question? That's the only thing I can find space
Yeah.
for transit user,
I mean,
where it becomes relevant.
I guess we're trying to make those pathways regardless, right? The pathway for pedestrians, bicyclists, and motorists from a property to the transit station.
I'm trying to find justification for it, but I think that your point of pedestrian or bike coming off transit is pretty much, as long as we provide, if we provide for bikes and peds, then we've provided for transit users. Unless there's just something about that pathway or the timing of it or something. I'm searching.
It's just a question.
It may also, there's a lot of identification potentially too with people taking different modes of travel. And so if you're identifying yourself as I'm a transit rider, I'm a bicyclist, I'm a pedestrian, I take a carpool, but whatever it is, there may be something to be said for inclusion of that persona, I suppose, if people are choosing that mode or must choose that mode, then they would also be included and a consideration of when we're planning for something or addressing an issue, that it's inclusive of each of those modes, I suppose.
To that point, maybe it comes more down to wayfinding and signage. Maybe there's something specific about signage that needs to be figured out. I know that one of the signing code adjustments was for the Metra LED moving light signs, for lack of a better description of those.
I forgot how close we are to rail transit. That would be the other piece. Thank you for including that.
So, and Commissioner Pelletier's comment is making me look at, the standards for site plan review, which is one of the places where this reference to transit users was added. In subparagraph 4 is the design of landscaping, screening, and related improvements to A, B, and then C, create a desirable and functional environment for motorists, pedestrians, bicyclists, transit riders, occupants of residential dwellings, business owners, and employees. And what that gets me thinking is, this is a site plan review that, to me, the greatest thing it's doing is serving residents of this village. And by putting in that long list of people, I'm just wondering, shouldn't there be a priority of who is being served here? And shouldn't number one be residents, business owners, and employees? And then someone riding through Riverside on a train should not necessarily be at the same level as a resident who's living here, 365 days a year. That's what's occurring to me at this point in time. So when we're reviewing site plan review, shouldn't there be sort of a hierarchy of whose interests are greatest? And specifically here, it's for landscaping for site plan review.
In that same section, 4C, why is there an "and" between transit riders and occupants of residential dwellings? I mean, shouldn't it, if we're going to list off all of the individuals and the types of persons, shouldn't there just be a comma?
Yeah.
And then business owners and its employees?
Probably that "and" should be struck out, you're saying?
Yes.
Yeah.
But that doesn't address prioritizing those individuals, if that's something that we would want to consider. And I don't know how we would consider that. We create a desirable function and environment, and if there's a tie, we go towards the residents? Is it?
And I hadn't reviewed any of these changes with that concept in mind. It just occurs to me right now that maybe throwing in all these terms is somehow weakening or watering down standards in other parts of the code. I'm not sure. I think it's something we should consider.
Can I throw out the radical idea of perhaps just simply getting rid of C entirely? Because we've already got promoting and maintaining village standards for appearance and development quality, and then harmonious transitions to adjoining lots and development. Once landscaping does that, it's pretty much good enough for everybody else who happens to be in the vicinity, which is what C does. It's just everybody else.
Or we can just say, create a desirable and functional environment for everyone.
I considered that too,
For
so
all
I
people.
can support either one. But it's, if we have A and B, it should, by following village standards, be desirable and functional environment. That's the point of the landscaping standards.
I mean, I would be in favor of saying create a desirable and functional environment, either semicolon or a shorter reference, like that's consistent with village purposes, or something like that, not listing people in different aspects of their lives.
Well, I agree with you that if you do start listing out people, what if we miss something or someone? I think the intent is to make it a desirable and functional environment for everyone.
Can I support what you've said, is just, let's make it for everyone and end this trying to pick off people.
So just a semicolon after environment.
Yes.
Or for all users?
Or for all users. I'm agnostic on if you want to call the people out
I
or not.
support the semicolon after environment and just let it be. Just create a desirable and functional environment.
Period.
I guess that should be maybe a period, because that would be consistent with A, B.
Yep.
Anything else in this section? Commissioner Miller, as I go through these, I'll try to keep an eye to, or Pelletier, is transit rider included where it should be included and not excluded?
Okay. So on to chapter 4, which speaks to residential districts. This section has a couple of comments about, the revised district names to ensure consistency. There are purpose statements for the uses. Again, that language about emphasizing safe and accessible spaces for pedestrians and bicyclists in the bulk requirements section. Talking about naming or renaming use designations. So instead of, senior living or elderly living living space. You have facility, sorry. There might be assisted living and a change from elderly to use of senior or older adult. There's an added new use of electric vehicle charging station in residential districts. And then it talks some about the building heights. So there's plenty to discuss in this section. And I'll let you select what you want to speak to first.
Thoughts?
I wanted to say something about the electric vehicle charging stations, but I don't have my notes in front of me right now, so to find out exactly what I was going to say at this point. So give me a moment.
In the purpose and intent in 10.4.1, we change it to that collectively encourage greater walkability and enhanced access. I just think greater than what and enhanced as compared to what. So maybe just take out those two words, that collectively encourage walkability and access to transit.
Well, I was concerned that the way this is phrased makes it sound like that's the primary purpose of the single and two-family resident districts, which I don't.
It's not.
It's not. And it's just, I thought it was awkwardly inserted. And then that next, the way they changed the next sentence, lots are at least 5,000 square feet in area is like an incomplete sentence then.
So just look some at 10.4.1C and just ensure that whatever language is used is reflected in the other D and E. So the emphasis is taking out that greater, correct? So we're in,
Well, I think Attorney Marr's suggestion might be to remove it, to just not have it, because it's not really the intent of the zoning.
I support what both of you are saying. I'm not sure sorry, I'm being too loose on this. It really, that is not the purpose of the residential zoning lots. I mean, essentially, every residential lot we have has a sidewalk in front of it, which then makes it walkable and transit accessible in this grand scheme. I'm not sure what else you would do to our zoning classification to make it more accessible to transit. So I'm supporting the removal of the language.
I agree. It doesn't belong there.
Yeah. It's not to say that we don't want to collectively encourage walkability and transit
Right,
access.
well,
It's
there's
just not-
plenty of other references throughout this to
Right.
those concepts, so I don't think we need them here.
Complete Streets does that, to be perfectly honest.
Yeah.
That's the whole point of Complete Streets is pets and bikes and making sure that they're accommodated.
So strike all three. Other comments?
okay, so also R3 and the R4 where you have some mixed office and other residential, right? At all of them? Okay, okay.
And sorry, to continue beating down on this, we've got the section 10-4, or sorry, 10-4-2, and it has the additional sentence of, as well as provide for walkability with enhanced access to transit. So that puts it in the right spot
Right.
in this language.
Although I would remove enhanced, because enhanced relative to what?
Yes. Your point's good, or I agree.
Okay, so that's 10.4.2? Perfect, thank you.
So then I think just in general, throughout whatever text changes, the greater, using those relative terms, we might want to stay with them.
And then, well, continuing into the next one, 10.4.3A. Is it a purpose of the bulk requirements to create safe and accessible spaces for pedestrians and bicyclists? Aren't the bulk requirements basically dealing with what happens on a private lot? I mean, they're not addressing things like driveways or sidewalks, as far as I understand.
Please.
I took that reference to mean, like, it includes setbacks. So, a front yard setback, pushing the building back a certain space from the public street and sidewalk, that kind of thing.
How does that really help?
Yeah.
I'm
just telling you how I understood what they were getting at, I guess.
I think it's got a good point, and I'm agreeing with you, Attorney Mars, is that it's providing additional justification to why we have bulk requirements. We do want to have the building set back a certain distance from the walking path or whatever it might be, so that you do provide that openness.
It all sounds to me more aesthetic than pedestrians. Like, let's say we just reviewed the petition for the property at the corner of Harlem. There's a sidewalk bordering that into, if he was allowed, wherever he was allowed to put his parking lot, the fact that goes right, I mean, in fact, we even allowed the parking bars to be moved over a little bit. That didn't impact the pedestrians or bicyclists. I'm just not sure if in bulk requirements, to me, that's the right place to throw in this additional language.
Bulk requirements are really for the building, though, not so much the
Right,
placement
that's
where
my
the
point.
parking.
So what you're saying is that by establishing buffer yards and side yards and rear yards and front yards, that's helping pedestrians and bicyclists to feel comfortable, as opposed to being in a city where you could have a building right up to the sidewalk, where they might not, they'd feel less comfortable walking down that
Yes.
sidewalk. I think that's debatable, but.
You can put in bulk requirements also can help create. I mean, it's not necessarily at all times.
In the
Creating.
sentence says
Or-
bulk requirements also help. So it's,
It's secondary. It's not the sole purpose.
right.
It's not even necessarily saying it's the purpose, it's just
It helps.
qualitative sentence, yeah.
Yeah. I don't know if that, quite frankly, I don't know if that additional language adds any value to the definition of bulk requirements, and perhaps it's not necessary.
I just went through the bulk requirements online, and the only thing that is all related is the street yard, minimum street yard, and to others' points. So, it's not really going to help things.
Right.
So we're in favor of removing that sentence?
Let's remove it.
Commissioner Matthews, are we still connected?
Yes, we are.
Awesome, thank you. Just checking.
No, I appreciate that. Strong feelings about this, I think folks are already saying, pretty much in agreement.
And can you hear everybody okay?
For the most part, yeah, if I have trouble, I will ask. Thank you.
So I think the next portion is the bulk requirement table. And I guess I would like to hear what people think about assisted living facilities and independent living facilities being listed as special uses in every residential district? Or is that okay because we still have the bulk requirements for buildings?
I had a question with that as well. I'm not that familiar with what goes into building an assisted living facility. What would be the reasoning, behind making it a special use across the board and not a permitted use in some residential areas? Is there something that I'm missing with regard to the structure and the use of assisted living facilities? Why it should be a special use?
That's a good question. Why was it removed from being permitted in R3 and R4 and changed to special, and then also added into R1 and R2 districts? I don't understand.
I had the same question or thought, and I would actually remove assisted living facility from the R1 districts entirely.
I do remember us talking about this at one of the steering committee meetings, and Trustee Pollock was eager to have it changed from permitted to special use. I don't recall the reasoning, and I don't recall us specifically talking about making it special use in the R1s, or R2 for that matter. Do you?
I don't remember that conversation, and it's possible that I may not have been part of that conversation. But you know, when you think of, and certainly the type of development can change over time, but you know, going through communities, that there has been over time, recent years, an increase in a need for assisted and independent living facilities. You know, or nursing care, or whatever you know, definition you choose to use that building for. If there were to be an amassing of land where someone would be purchasing properties in these residential districts for the purpose of constructing a residential, you know, senior living facility, you know, the bulk of that property, you know, could be larger. It's not, you know, they're typically taller, larger than a single-family home or even a duplex or an apartment building often, and also require an extensive amount of parking sometimes as well. And so by not, you know, eliminating that as a possibility, if there were to be appropriately, you know, something that's deemed appropriate for that particular use, they would have the option to take that as a special use consideration before this body and the board, and depending on that circumstance, rather than permitting it outright or, you know, allowing for that.
I'll be honest, that description plus it is actually defined in our definitions, and I'm gonna pick off the hot button words here. Institution, common dining facilities, definition includes nursing homes, congregate care facilities, but does not include independent living. So I'm still going to support my idea of remove the special use of assisted living facilities from the R1 districts, but leave the independent living as special uses down at the bottom of that table. We already know that we're going to revisit special uses for churches and schools in residential, and the specific concern was that those are in danger of exceeding, shall we say, too much massing in residential districts. So I'm not understanding why we would allow a special use for this.
What about the R2, which is primarily south side of Burlington and north side of Quincy? The two-family residence district. Keep it as a special or just remove it?
I could leave it as a special, simply because that R2 does have two-family residences. And in my mind, the assisted living facility is going to be for multiple residents.
Others?
So what is the proposal, Commissioner Mahal?
The
Repeat.
proposal is to remove the special use from the R1 districts,
For both assisted living and.
only for assisted living.
So leave assisted living as a special use in R2, R3, and R4. Do not retain the permitted use in R3 and R4. Make them all special uses.
I haven't,
Because right now they're permitted uses in R3 and R4. You see the P is struck out.
I do. I think we open it up for discussion.
I don't see a good reason to not retain it as permitted. And the same for independent living. In the R3 and R4, why not retain them as permitted? Have there been any issues with that? But I agree that I don't think it would be appropriate to have assisted living facilities in the R1 and maybe the R2 district. And I'm not clear on what independent, I know I read the definition here, but I'm not clear.
I'm
Independent
actually,
living means institutional or not, or just a house.
I'm rereading the independent, and I think the biggest element of that is it could be, and somebody needs to challenge me on this, independent living is essentially,
Do you mind reading?
Independent living is defined, that's what I'm looking for right
yes,
now.
it's, independent living is defined as a multiple-family residential complex containing dwellings that are limited to occupancy by persons who are 55 years of age or older, or if two persons occupy a unit, one of them shall be 55 or older, but it excludes assisted living or institutional care, such as medical or nursing care. These complexes may allow minimal convenience services, but focus on attracting older residents to provide social support system among the residents. Based on that definition, I would also remove that from the R1.
Attorney Wright?
I-
Go ahead.
I don't know if, I think that, I'm not quite sure, but I think that there are groups that provide group living for a small amount of disabled adults in residential areas. And I don't necessarily want to exclude the ability for those groups to manage a home and a residence for, 2 or 3 adults that perhaps have a caregiver live with them or take care of them. I know that in other communities, I'm thinking of Naperville. My sister actually lives across the street from a home where there's 3 adult disabled people who live in the home, who live in the residence, and it all works out just fine. So would we be excluding that by not allowing, is that, I would think that that would be in the definition that you're excluding from the residential district.
It is, and I'm equally troubled by that.
I don't think it would, because the definition, at least for independent and also assisted living, is multifamily.
Well, then I think we need to look at the definition of independent living, because it seems like it's limiting to people over 55 years old or older.
Right, it does, yeah.
Good.
Attorney Morris?
The type of facility you're referring to are often in zoning codes defined as group homes.
Okay.
Is the terminology that's used, and there's small group homes, there's larger group homes. There's a whole body of federal law and case law surrounding those. So typically, the independent living and assisted living facility would not encompass those.
So actually,
They're called community residences, and
Mm-hmm.
they are allowed in the B district, B1 and B2, I think, in our code.
Oh,
And they're
they're
not
there, yep.
included in the use table for residential.
Actually,
Right, so rather than group homes, you're calling them community residents. I see that, large and small.
yeah, and community residence small is
They are.
permitted in R1, so
Okay, well, then that takes care
I
of my
think
concern.
I think I'm not inadvertently cutting out the community side of things.
Right, I'll clarify for anyone following, the existing permitted uses table does not include community residences as permitted or special use for considered large community residents, so anything more than 8 residents. They are allowed permitted use in R3 and R4. And then for small community residences, 8 or fewer residents is a permitted use in each of the residential districts. So there's no changes being made or proposed through this discussion to that. And I found the definition for that, where we're talking about a group home or specialized residential care home licensed or certified or accredited by appropriate state or federal agencies and serving as a single housekeeping unit for the housing of unrelated persons with mental or physical disabilities who share responsibilities, meals, recreation, social activities, and other aspects of residential living. They do not include, community residences do not include residences which services persons as an alternative to incarceration or criminal offense, or a primary reason of placement is abuses, and it does not include nursing or medical facilities. So that gives you an idea.
So why does that not encompass assisted living and independent living? Wouldn't they?
I would imagine it's predominantly an age restriction. So when we're talking about independent living, they're typically defined as for older adults, where community residences can be for any, independent adult age. And then
But it could also be restricted. I mean, I feel like the community residence, large and small, is sufficient to cover.
Well, some allow nursing and some don't, and assisted living would require nursing, I think.
Assisted living provides common dining facilities, medical and/or nursing services, housekeeping, laundry, transportation, organized social activities.
Right. As
And
opposed to
that's-
living
it's-
as a single household.
Right.
And that does reference older adults, just like the independent living is for older adults.
correct.
So that's why the community residence is different.
So the differentiation is that, an assisted living care facility would end up providing those types of services as needed to residents of that community, rather than a nursing facility where you'd find that to across the board, those types of services, and independent living where they could be independently providing those services or seeking them outside of that home. So.
This discussion does make me wonder if we should consider making the small community residence a special use in the R1AA and the R1A and maybe the R2, I'm not sure, just because of the potential disruption, I think, that could occur. I'm guessing we don't have one of these, as far as I know, from lots of cars.
We have several.
And- Okay, well, I didn't know that, so maybe it's not an issue. But I'm just thinking, is there an issue with cars and people going in and out and stuff like that? Would it be disruptive to the R1AA or the R1A, single-family residential districts?
It's a good question. I don't recall any complaints concerning the homes.
It's also possible that persons living in community residences may not be regular vehicle users. So
Yeah.
the people you would see could be the person that's assisting them on a, whatever basis they choose to provide those services.
I agree. That's typical.
Okay.
Yeah, based on the definitions, the whole point of the community residence is trying to create a household of sorts. So that's why it fits within the R1, R1A. I think your point is good about too many vehicles, but we're not seeing that, and that ends up being an enforcement issue more than anything.
I wanted to jump back to Commissioner Miller's point about the special use versus permitted. And just point out, so Chairperson Mateo had said that Trustee Pollock was advocating for these to be special uses, and, you know, I wasn't part of the steering committee meeting, so I don't know why that was, but I would guess that part of the reason is when you have a permitted use, you're just going in and doing it, whereas a special use is really saying, we as a village are okay with this use in this particular zoning district, but because of the specific impacts it may have at a particular location, we want to look at them on a case-by-case basis, make sure the traffic flow, the site plan, all those things are appropriate for the location that's been chosen. So that's sometimes why something is made a special use.
And at our last meeting with Attorney Molina, I kind of raised that issue of whether Riverside's special use standards are sufficiently strong to provide any functional control over whether to allow a special use or not, or whether to mold it in a way that is not disruptive. And I happened to point to LaGrange's special use standards. That's only just one I happened to come across. It seemed a little bit stronger to me. Because, for instance, if someone was to put in an office on the ground floor, or asked to put in an office on the ground floor in B2, I'm not sure, given our standards, we would have any good basis for denying it as a special use and saying, this is so out of the ordinary, this use is so out of the ordinary that we can't allow it here. So that's what would be my suggestion.
Is that we look at the special use
Yes.
standards at some point?
If we're going to be serious about it.
Sure.
Or, you know, so, yeah.
I would suggest that the assisted living facility and independent living maybe have the same definitions of large and small.
Or
And
break it into
change-
subcategories.
Yeah, and maybe a small is a special use in the R1 district, but not large.
Seems like something worthwhile considering.
Well,
Just seems like the intensity of use in the R1 districts is a lower intensity of use and geared more towards a smaller living unit, if you will.
it's a great suggestion. My hunch is that anybody who wants to develop an assisted living, they're going to have more than 8. So we would have to maybe think about
Right, for it
what's
to be
large and
profitable,
small.
they'd need a critical
Yeah.
mass of people.
And at least the way I read the definition of independent living, I'd be surprised if it did ever get over 8 or get large.
I just think it provides a little more control.
I thought you were suggesting making this, one of the small ones, permitted use in R1.
I was suggesting special use. And larger not permitted in R1.
Other thoughts on that?
For independent living, that sounds reasonable. To do the smaller as a special use in R1.
Any thoughts on that? Other commissioners? Wait, so I'm clear on what you're suggesting. Let's stick with just one type. For independent living, come up with some arbitrary cutoff for large and small
An arbitrary cutoff that we have already established in other
for the community residences?
definitions,
Okay,
yeah.
and so then you would recommend keeping it permitted in 3 and 4, making it special in 1 and 2?
Yeah.
thoughts?
Can you repeat that? I'm sorry, I was.
So for
Special
small.
in 1 and 2,
for
and
sm-
permit in the others.
So
Yes.
so for small independent living, I'm hearing special in R1 and then permitted in R3 and R4. And so where does R2 go?
I could go either way, but
For independent, I could go, I could go with permitted in R2 for the smaller. That fits the existing intensities. And then for independent living large, we're saying not at all in R1, and then special in R2, and are we still continuing permitted in R3 and 4, or putting it back to special?
I don't have an opinion on that. I would be okay with having it permitted, as it is currently.
Permitted seems reasonable when we look at the R4 the R4 and R3. R3.
Other thoughts? So again, for the large independent living, leave it blank for R1 and R2, and you're suggesting permitted for 3 and 4?
Correct.
This is for independent living. What about for?
Independent living large.
Okay, so we're splitting, the suggestion is to split independent living into large and small, like community living. What about assisted living?
We haven't gotten that one yet.
Oh, I'll wait.
And so that's not permitted in R2, the large independent living.
Correct.
right?
That's what I think we have come. And then for large, and I'm somewhat unsure on this one, for R2, is it special or permitted? Based on the intensity of use, special.
Which one are you talking about, large or small?
Large independent, special in R2.
Rather than leaving it blank?
Correct.
What do others think?
I'm okay with that.
And what are R3 and R4?
Permitted, as they were before.
This is one of those things that we can certainly think about before the next meeting, and with all of our free time, maybe look to see if other communities, how they do it. And in case I forget, I really appreciate everybody's careful attention to these proposed changes. These suggestions are really wonderful. Okay, assisted living. Commissioner Pelletier suggested dividing that into large and small facilities. What would make something large?
I mean, I would just use the same numbers, just because, for consistency. And if we don't think that makes sense, if it doesn't make any sense for someone to open an assisted living facility that is limited to 8 residents, then I would suggest that it not be permitted in R1 and perhaps be special use in the others.
For large?
Well, basically, if it doesn't make sense to create a small because it doesn't make economic sense.
Oh, economic sense, right.
Right.
If there is only one, then I would not be in favor of it being permitted in R1.
So when I'm sorry.
Go
can I
on, I'm
just-
sorry, yeah.
So if it's an assisted living facility, does that mean that's not like a group of people who get together This is like more of an institutional commercial. It's not just people who know each other, who are related or
Assist-
something.
Yeah, assisted living in the definitions we have, this is a communal living facility. This is a dorm
With staff.
with
With
staff.
Staff and
But not
medical.
like someone who's just,
Cooks.
like, some cousins or whatever who decide to live together or something like that and hire a housekeeper.
That's
That would
just
be
a
something
house.
different. Okay.
So for a large assisted living facility with more than 8 residents, what would you like in 1, 2, 3, and 4?
For large, I would say, as Commissioner, if I may parrot what Commissioner Peltier said, is not in R1 at all, perhaps special in R2, and then we have to decide if it's permitted or special in R3 and R4.
And I would suggest we just reflect what we did in independent living.
I think that's
So-
fair. The only thing that I wonder about, again, because I don't know what I'm talking about, is the issue of, in these R3 and R4 districts, I'm thinking about traffic and parking and vehicular use, if that would be a reason to make it special and not permit for a large assisted living facility.
To me, an assisted living facility, and it says in the definition itself, an institution, so I think of a larger establishment. Also, the fact that it's providing medical and nursing services, it might be a situation, to your point, where there might be ambulances and certain medical ins and outs
Yeah,
coming
that's a good
coming and going. So that type of, I'm having trouble with the definitions because, and I think this will require more of my time to look at assisted living facility, independent living, and communal living side by side, because I think that there is some overlap. I think that there's a situation where there can be an elderly group of people in a community home, and I certainly don't want to single out elderly adults and prevent them from being in an independent living situation or a community living situation. Perhaps assisted living facility, that definition needs to be a little bit more, and maybe it already is, but it needs to be defined as more institutional and more like of a business type situation. And if in fact that is the definition, I would support that not be in a residential area, but, more in a business zone.
Hey, can I interject here? It's hard for me to know when to jump in.
Please do.
So I guess my question, and I'm not even sure if this is an appropriate issue to raise, so I'm hoping Mike is listening very closely and will shut me down if it isn't. My concern when I saw assisted living, to begin with, as opposed to like a group setting of independent seniors, assisted living facilities in many cases are faith-based. And in those cases, that property, I think, goes off the tax rolls. Now, is that something we should be considering about, for this? And I know, I'm aware we can't say, you can't have, you can't have a faith-based one, but you can't have a private corporation. I'm not suggesting that. I'm just wondering if this is something that we should be taking into account. And I'd kind of like to actually, I'm not sure who's speaking before me, but said I'd like to look into this a bit more and actually see what other communities are doing and whether these issues have been thought out.
Right. So in answer to that, I would say, generally, a legal use, you have to allow it somewhere. But I do think your point goes to this idea of, do we want to shift this focus just because they're larger over to our commercial business districts because we have very limited commercial business areas? Do we really want to emphasize kind of pushing this kind of non-tax generating facility over to the commercial areas? And The answer is probably no, but that's a policy decision.
Right, I think that's a good point. And right now, I guess our current code says that you can have assisted living facilities in the B1C and the B1TC, and maybe we should be reconsidering that.
And that's next month's conversation, right?
Yes.
Business district. So Commissioner Braun, I think, was suggesting maybe don't allow any assisted living, or at least large ones, in any residential district? Or am I putting words in your mouth?
I think my suggestion is that I need to compare those three definitions that I pointed out. I do think that there's some overlap, and my suggestion was perhaps we need to look at the definition in particular of the assisted living facility, and we have to be in line with, what exactly we all understand an assisted living facility to be.
I support that, and I think to get back to where you started, rather than permitted in R3 and R4, I would go to special
Right,
because of the potential impacts,
correct.
I agree with that.
which
mean, be-
which
because-
fits the revision that,
Yeah. I was going to say, because this issue seems to be something that people want to look into a little more, and it's less transit-oriented, I'm not sure, why it's suggested to begin with, but I'm sure there's reasons that were talked about. Is this something that we could pull out of this particular part of it and revisit, or how do you want to do it?
I would anticipate so. I think that this was a full-scale opportunity for us to review the zoning code in entirety, and, adopting this specific to the TOD, process. I think you can make an argument either way. There will be instances where persons living in any of these facilities will benefit from,
Sure.
enhanced access to transit or walkable spaces or whatever, but certainly this is not something that hinges on adoption of TOD practices.
I mean, the other alternative is just to say, here's our rough idea, which you guys have pretty much done, and everyone look at definitions, maybe look at what other towns do, and we can revisit it at the public hearing or prior, however you want to do it.
And we're not going anywhere. Oh. But we can take out elderly and swap out that word,
Okay.
please. Other comments in this section?
So I do have I don't know if this is right, the electric vehicle charging station. The whole concept of that, and specifically looking at the new section 10-8-10, as well as, which is referred to in the bulk table. So in the bulk table, electric vehicle charging station is added as a use that is not categorized for R1A, R1A, or R12, which I assume means it's not allowed. And then it's listed as a special use for R3 and R4. And there's a reference to the new subsection 10-8-10. And then we can look at 10-8-10. And the problem I have with this, I think that this should be totally reorganized and recategorized. As I read it, the electrical vehicle charging station is defined as anything from 1 to 20, and they're all lumped together. And then in 10-8-10B3, there's a reference to private single-family home electric vehicle charging station standards. I don't think that should be in zoning at all. I think that whole section should be taken out. I think if there are issues with safety, that should all be in the building code for putting in a private electric vehicle charging station, which is for one person. And if we're concerned about people selling that service, well, we have the home occupation standard. So I just,
I'm uncomfortable with all of this. I think it's far too, in some ways, too complicated and not functional the way it works. So basically, I think there should be a differentiation between a private and a private home for private use, a use by a business for its employees or customers who incidentally are there. You know, like at Nordstrom, if you go to Nordstrom and there's a charging station you can incidentally use, but they're not charging you for it. And then a commercial use where someone actually has like a charging station for 4, 6, 8, 10, and you have to pay to use that. I think there should be that type of differentiation, and then we should look at where each of those things are allowed. And if we want to encourage it, I don't think we should be putting new standards on private homes and saying you've got to meet these new standards if you're going to get an electric vehicle and you want to be able to charge it at home. Thoughts?
I definitely agree there should be a differentiation between, you know, a charging station in this, it really should be kind of the public use type charging stations. And it does make sense that if there's special standards for a private use, I mean, right now you can plug your electric vehicle into your garage or whatever. And, you know, I'm not sure that we want to change that ability.
Right.
Or impact it significantly, unless it is unsafe. But
Right, and that should be a matter of whatever it is, electric code or building
And
code.
that
or
would be
whatever.
covered under the building code.
Yeah.
perhaps,
Correct.
that makes sense.
You know,
Is the 10-8-10 language in here?
It's, I have a printout that Ashley gave me last meeting. It's on page 123 on my printout, but that's from last.
Yeah.
It's not in the memo packet, I don't
Right.
think.
Okay.
But there is a reference in the bulk table to 10-8-10.
So I guess my question for the commission, and again, I'm saying this is coming into the conversation with the steering committee a little bit late. What about instances, so it's proposed that there's a special use for electric vehicle charging stations in R3 and R4 existing zoning districts. And my question would be, how to differentiate, for example, a apartment building that has many residents that would like to install a private use of a charging station. Is that something that, you know, I guess where in those definitions would you like to categorize that? Does it belong here? Does it not belong here? And if it does belong in the table where it's cited now, is that something with, you know, I guess further tailoring of that definition that you would feel comfortable allowing with a special use in, you know, a parking lot with 12 vehicles, and some of them being electric?
Is we could define an electric vehicle charging station as one that is for, you know, commercial use on a retail basis or something like that. Those are what are regulated. Things that are in an apartment building or multifamily dwelling or single-family home are excluded from that definition. That, to me, is appropriate. And we can, if we need to, I think there's some additional language already in these TOD changes, encourage a building owner or, you know, a new developer to add electric vehicle charging stations.
I think Commissioner Miller hit it on the head. It's, the issue is it for personal use or residential use versus commercial use where any random vehicle can come up to the site and use it? And in my mind, honestly, if it's in any one of the R districts, then it really should be for the residents specifically.
Right.
Otherwise, it's a commercial thing.
Or incidental use for a friend. I mean, the way I think 10-8-10 reads, it's like if you had a friend visit you with their electric car, maybe they can't charge it legally in your garage. So, yeah, that's how I would cut it.
So wouldn't it just be an accessory use then, if it's personal? right? Just a permitted accessory
Which I think
use.
then just gets to building code,
Right.
install it safely.
I have no idea if you even have to call it out as an accessory use, or it's just like,
It's essentially just a piece of equipment.
Yeah.
I mean, it's
Yeah.
a pedestal, like,
Or just an
Right.
outlet.
it looks like a hose bib. I mean,
Right.
let's be honest, it's not much more intrusive than that.
So during the steering committee discussions with the consultant, I'm the one who asked about this, because I think the green parking lot someday might want an electric car charger.
Right.
That would be great. He hadn't, if I recall correctly, this wasn't part of code that he had really worked with before, so he went all in and really put a lot of information into the suggested text, but I think commissioners are right that we can probably tweak this and make it more Riverside friendly or Riverside appropriate.
Okay.
I think it should be encouraged. I think in the B2 and B1 districts, I think absolutely it would be great to have that established. I mean, I think right now, if it was established, it could actually be something of a draw, because at least with Tesla, if you're looking for a charger, the map in the Tesla shows you where the chargers are. And if someone said, oh, there's one in Riverside, there's, 6 stalls in Riverside, they might come into Riverside and plug in. And I assume that's the same with other types of electric vehicles, so.
I believe so.
So if it turns out that we don't have it in the residential districts because it's private use, do you still have your concern about multifamily, multi-car parking lots? And aren't they typically assigned parking then?
I think it depends on the resident. I think it depends on the owner. They either,
Yeah.
if they're flexible and collaborative enough, then anybody gets a spot, and if they have issues, then everybody gets an assigned spot. But again, I think we're back to, if it's used for private use or residential use, then it's really just a piece of private property that doesn't need to be in the zoning code.
Right. So if the definition calls it out essentially as commercial use, right, then we would just take this whole line out of the residential use table.
I think so.
And I don't think I just looked at the definition, I don't think the definition calls it out as commercial use at all. I think it's just a general, the definition of the electric charging station.
Yes, like functionally what it is.
Correct.
right?
Right.
Correct.
So that could, if you look at that definition as it is written, it could apply to the residential charging stations. So
So we're going to change that definition.
we need to change that definition.
I think you're
Or
correct.
exclude residential charging stations from that definition. Rather than say that it's commercial, just exclude residential charging stations.
I don't want to extend the conversation further if it doesn't need to be. However, the only other exception I would put forward that may be included within an R district is institutional uses like schools, churches, others that may end up wanting to install such a piece of equipment. And so having a mechanism for them to do so or be considered for being able to do so, things change over time and it may be increasingly common, at which point we could revisit it or think forward and determine whether that's something you'd like to see or provide an option for.
But again, I don't know that we have to even mention, I mean, the way I'm looking at it, I don't think, so it is just a pole. It's like, it's not an above-ground storage tank, like an old petroleum tank. It's just a pole. It's not intrusive at all. I think it's great if the schools were to start putting these in, 1 or 2 or whatever, as long as it's for incidental use for your employees or your customers, and you're not charging someone, that's the difference.
I think Commissioner Miller has it right. It fits in the definitions, and it becomes who is supposed to be using that facility versus a purely commercial for pay, for hire use. Does
Okay.
that satisfy your concern?
I think
I think it's the
Find a
for
way
hire
forward.
versus regular users.
Okay.
So for next month, when we talk about electric vehicle charging stations in the business districts, just think about it between now and then, a little bit if you can.
Yeah.
And those standards that are included.
Okay.
What else in this section?
Next, we have minimum building heights. And the bulk regulations is the other section in 10.4.
Yeah.
Any issues there?
No, I think the explanation that had been given last month was adequate of why we were looking at this change.
I have one comment in the footnote at the end, just before Chapter 7, Site Development Standards. I need to make this bigger. It says, discretion of the Planning and Zoning Commission and Village Board. I would just like to add of trustees after Village Board. It's not like they're
I
going to
see.
send it to the Parks and Rec Board, but let's just be specific.
Where is that?
It's in the,
Right here.
It's in footnote 5 that's been added as a recommended language for institutions and
It's tiny.
I have a question as to what that footnote even means. What does it mean, a greater level of review? That provides no guidance, and how would that be implemented? And what's the standard for the greater level? I just don't, is it simply saying, hey, PCC Village, you might want to look at this a little closer? Isn't that obvious? Or is it actually imposing some additional either standards or requirements or guidelines, either to help out the village by saying, look, you can scrutinize this more, or impose a burden on the village? I just don't understand the point of the footnote.
I think it came out of looking at parking requirements and making changes if it's however many, like an apartment building, you need to have so many spaces per residence. I think what the consultant realized is that here in Riverside, we have St. Mary Church, we have the Ames School, we have some big buildings, properties, where a straightforward calculation isn't necessarily going to help us with a parking requirement. So if you think back to the St. Mary variation request, we asked, how often is that parking lot full? Or is it sometimes these people are here and they take up this much of the parking lot, sometimes these people are here and they take up that much of the parking lot. So I think it's just meant to provide some flexibility to those unique cases.
It makes sense. I think I'm not sure where to go with this note either, in the sense of typically we're talking about pre-existing special uses where anyone who lives adjacent to or moves adjacent to should expect that the church is likely to have services on a certain day. Schools are likely to have significant use, again, certain times of the day. So I'm concerned that the note encourages additional restrictions beyond what people should reasonably assume is going to happen.
Yeah, I agree.
The school, sorry, Attorney Mars, go on.
I just think to both of your points, when it says necessitate a greater level of review, that's just untethered to anything, so I'm not sure.
Could it get
And I
village
don't
in
like
trouble?
singling out religious institutions as part of this that were,
Honestly, I don't like singling out, and I'll admit a potential bias as being on the school board, but I'm calling that out so it's fully identified. But all of these institutions, whether or not churches or schools, have been in those locations for I'm guessing a minimum of 50 years, if not 100. So calling out additional scrutiny is, I don't believe it's helpful at all.
Right. So if they are designated as special uses, which I believe they are,
They
they're going
are.
to get the appropriate level of
Yes.
scrutiny when they come before you, regardless
Correct.
of this note, so.
Right.
I agree. You can't have that language. I don't think we should have that language. It's calling out certain, I think it's dangerous to have this type of language where you're calling out certain institutions or assemblies. It shouldn't be in there. It's not appropriate, especially if we're going to be having a level of a review in the special use process anyway.
Right, I agree. And if there are specific issues like parking issues, maybe it should be mentioned in another section of the code specific dealing with that. Like, the board or PZC could consider relaxing some of the parking requirements for, a large institutional use or something like that.
But all of the special use scenarios should be treated equally anyway,
Yeah.
and calling out specific special use areas is just not necessary.
I agree.
Okay, so we're striking that?
Got it on the list. Okay. Okay, anything further in that 10.4 section? Anything that wasn't covered? Okay. I'll move on to site development standards. These are focused on lighting, accessory structures, fencing, temporary structures, permitted encroachments. So the list, I won't list them out, but addresses each of those items. The couple of changes recommended, I'll highlight that the exterior lighting is focused on kind of dark sky practices, so eliminating or mitigating upward shining lights, downcast sort of lighting that focuses light tends to be both friendlier for your neighbors and for environmentally, and those have been adapted in there. And then there's a big list of accessory structure outlines, as well as changes to fences that adapt fencing requirements for business districts that are very similar in nature to what we have for residential. But it puts it in the code. I'll let you talk about this.
Thoughts, comments?
So for exterior lighting standards, I feel like we can be stronger in requiring cutoff fixtures and protecting the night sky. So in the 10.7.2 exterior lighting, we're talking about, it says all on-site lighting. So on-site to me means not in the public right-of-way. So I wonder if we can strike the first portion of that, 10.7.2B. It should just start with all on-site lighting shall be equipped with shielding and cutoff devices such that no light shall shine directly, because we make this exception for decorative lighting that would match the villages. And I'm just not sure that that is necessary or desired. I think that all site lighting should have cutoff and should not produce glare. I mean, I know that I'm kind of saying that we are not allowing site lighting to, match our acorns, but maybe there's an acorn out there that does decrease glare. I'll admit it is a pet peeve of mine that our decorative lighting creates a lot of glare. It's a lot of wasted light that goes into the sky. So I would just rather not allow it on site.
So you want all the gas lights to be retrofitted so that
I'm saying on-site. I'm not saying in the public way. I'm just saying that if you're going to have on-site lighting, it should not produce glare.
So I'm sorry.
You should use cutoff fixtures.
So what but you want to get rid of that opening phrase about the gas lights?
Correct. Because to me, this is talking about site lighting, not lighting in the public way.
Yeah, it really would have, what Commissioner Peltier is saying is that the public way lighting is not, we're not regulating that in any way, shape, or form. It's simply that we are going to regulate what is on the property of the,
On the private property.
on the private property side. Thank you, sorry, lost my train of thought.
This applies to both residential and business districts, right?
I think so. Sorry.
I believe it does because
Yes.
it's reading A and C.
Yeah, so it's referring to B2
Okay.
and so I would apply it, when I referring to this in the code, I would apply it equally.
So do we like Commissioner Pelletier's suggestion of taking out reference to the gas lights right there?
I think it makes it cleaner, yes.
Okay. I had a question about that sentence that's added to further help with this effect. I wonder if we can anticipate how many lights on businesses are going to be non-conforming as a result. And I'm wondering, does staff have the capability of monitoring this?
Which, I'm sorry, Chair Mateo, you said which sentence here?
So in 1072B, the first red line, to further
Yes.
help with this effect?
Oh, okay. So, in one respect, there are things that may, we do have a tool that can measure, lumens and foot candles, so that if there were to be a call to match conformance with the code, we certainly could proactively go out and do that to see what businesses are in compliance and non-compliance with the existing code or any proposed changes. When we do design review for, just an overall for our building plans and their adherence to the zoning code, anything new would be addressed in that way. There may be also things that people would have in you see it often with connection to signage. And so if we are, again, proactively addressing signage where they would have these floodlights that are lighting up a whatever wall sign, we could potentially address it in that way as well. So having a reference to, again, create these downcast lighting, aiming, more narrowly focusing those floodlights or having cutoff shields would be a tool that we could use to address, these errant lighting issues. Did that answer your question?
I think so.
Okay.
We're not going to go out and start citing businesses that don't have completely recessed bulbs.
There's also in
No.
1072C, it does say that all lighting installed as of the effective date shall be allowed to continue. Is
long
that
as it's
sufficient
maintained.
to allow the wayward to continue to exist?
And then in the next red line in B, the end of it, help guide the minimization of unnecessary light pollution and improve energy efficiency, not improvement, sorry.
Yes, I saw that as well. Thank you.
Okay. Others?
So I wonder if it's possible, 1072B applies to residential as well. So we are requiring residences to use cutoff fixtures. You know, I see a lot of lighting in the residential districts that is not needed for safety. It's not lighting a walkway, it's lighting a tree. It's directed straight up into the sky, which I feel is kind of a violation of the intent of this ordinance. And I wonder if we might consider not allowing that in some manner. That lighting should be for the purpose of lighting a walking path or for safety, not for aesthetics. Is there, I mean, we can make landscape lighting.
I agree
Not-
with what you're saying. I'm not familiar enough with our lighting code, but that is something that I don't like, what I call it, like the bank tree lighting, you know? It's like now everyone needs to have a spotlight on their tree, and it goes up into the sky, and I don't like that effect.
Commissioner Matthews hear you?
Oh, I'm sorry, speak louder?
Yes.
I'm agreeing with Commissioner Pelletier about the lighting, but I'm not familiar enough with what our lighting standards are right now. I think there are a lot of lights in the residential districts, and a lot of them are like temporary lights people stick in the ground that shoot into the sky and are not for safety, and they're not for lighting a walkway or for anything else. So I'm supportive of changes, personally.
Well, every motion-activated light on somebody's garage is going to be at odds with this proposed code. You just have floodlights.
Yeah, and lots of people have lights on trees, which are like 20 feet up in the air, and they shine into other people's yards. But those are lights that have been there for, a lot of them for decades too, so.
I'd say, hoping that I'm threading this needle, I support the idea, but I think the enforcement is going to get rough.
How
Are
about
we-
consider ornamental residential lighting at another time? Is that okay?
Okay. Reluctantly.
It's on the list.
I will note that we do get comments. I've had a couple of questions and inquiries from residents about about the lighting that's disruptive in neighborhoods, and having something that addresses appropriate, lighting per zoning code would be helpful. So it's not a rush, but I'm certainly on board with discussing it further. So. Anything else in that accessory structures? And this is pertinent specifically to the business districts in 10.7.3.
In 10.7.3, how, do we have a list of these historically significant accessory structures? Because that is in 7D3. It notes that those are allowed.
I would gather that they likely are referring potentially to coach house, very likely. And yes, we would have a record of what those are.
These are in business districts.
Oh,
Well, maybe the
Good point.
dentist across from Labara, is that landmarked? Does anybody know?
I don't know if it's landmarked.
But it's still part of our landmark status, so maybe their garage, as you noted.
So you're just asking if there's a list, and
I'm just asking, is there a list of these, of the historically significant accessory structures in the business districts?
well, as an appendix, there's the list of all landmarked houses, right? And those could be looked at to see what their addresses are, but I don't know the answer to that.
And then I tried looking at the definitions, but how are we defining temporary? In a few places, it mentions 30 days. I saw a 45-day mention, but temporary is mentioned throughout the code revisions. And it needs at least a definition.
I totally agree with that, and also permanent, and this is for the residential bulk changes as well as the business. I don't see a definition of what, for instance, permanent outdoor seating is. Is that a wall versus temporary outdoor? I mean, I think since we're adding these references, I think it would be beneficial to have definitions, at least of temporary outdoor seating and permanent outdoor seating, and a definition of what temporary is and what permanent is.
For example, temporary membrane structures, which is later on in this, it has a 30-day limit and then a 45-day. It makes sense, but it needs to be applied consistently.
Yeah, there's definitions of certain temporary things, but
Those definitions don't include a time frame in which to consider them temporary. It's just their existence.
Well, Ashley, isn't the temporary permanent distinction often just based on whether something's permanently affixed to the ground? So that's how I took it.
What do you think?
I don't know, I'd have to look. I'm not
I think
sure.
that is a portion of it,
Yeah.
but if I have something that's temporary and I say it's temporary and it sits there and it's really heavy, then it ends up staying there for 10 years.
Right.
So it's not really temporary in terms of a time measurement.
what if you have a business that has outdoor seating and it's some type of chairs, but they're there all the time? It's not temporary. They don't take them,
And
put them
there,
out on Memorial Day and take them in on Labor Day.
and there is mention in the permanent outdoor sales and display, or sorry, permanent outdoor seating areas, it notes that temporary seating shall be permitted to preserve the ability to move it around and store away during winter months or inclement weather.
And then my notes show that in the business district, somewhere, there's a reference to permanent outdoor seating not being allowed on business properties that are adjacent to residential properties. So again, that begs the question to me, well, what is that? Shouldn't we have a definition of what permanent outdoor seating is and what's not permanent to apply that restriction?
Okay, so we need to clarify in certain places, temporary versus permanent. What else in this section?
Just curious, there's a reference to swimming pools. Is that just
That's one of my-
aspirational?
That's one of my comments. Why would we allow a swimming pool in a business district?
I suppose it's possible to have a hotel somewhere, but it's just, I don't know.
I may be incorrect, but I'm looking at the zoning map. It could be, is the Riverside Swim Club located in a business district there in
No,
B?
it's
No,
R1.
it's
That's
R1.
the R1, okay. Well,
It
it's
was made
adjacent
R1
to-
maybe 15 years ago. It used to be R4, I believe.
Okay. Yeah, I see it here. It was mixed in, right next to that B2, right in that area.
Well, so if we do keep swimming pool, I'm assuming they're referring to outdoor swimming pools? Is that a bad assumption? Because if it's inside the building, it's not going to really matter what
Yeah.
yard it's adjacent
Right.
to. So do we want to keep swimming pool? Does it cost us anything to keep it?
It doesn't
It
cost
doesn't-
us anything. I think it gets more to the use of the ultimate special use that we end up discussing, or PUD.
So we can at least add outdoor to it?
Okay.
Well, so then on that, and then on the playground equipment, Is there a reason to not allow those things in corner side yards in the business district? Business districts. They're allowed in side yards, but not in corner side yards, so I just don't know if there's a.
With the side yard, it would be behind the building frontage, whereas a corner side yard,
This is a street.
it would be
Yard.
more by
Safety.
the street and sidewalk.
Right.
then.
But why not allow it, if someone wants to put,
Maybe
Swings.
safety?
maybe, but that's what you could put a fence up for. I just don't know if there's a good, I mean, there's another way to address it if it's a safety issue, right? And I was thinking, well, maybe
So-
it's a matter of irritating your neighbor, but then why allow it in a side yard of a business? That's all. I don't feel strongly about it, I'm just wondering about the thought process.
Well, can I ask a question first? Sure. Do we use the term corner side yard? Or are all side yards on a corner street yards?
I think we do.
we
Yeah,
do use
conventionally, I would talk about it as a street yard because of, it's because it is facing those two streets. It's not, I would have a hard time defining a corner side yard because you have the, either no side yard and a
Oh, I
rear
see what you're
yard
saying.
and the street yard, how we would talk about it.
Right, so corner side yards are business districts only.
And they are.
That's what this
there-
is.
There is a picture, there is a diagram in the definitions that does show a corner side yard.
Okay, so
So
that's
it
good.
it is defined.
Okay.
And this section is for the business district, not for residential. So,
So the use of corner side yard is appropriate.
Yes.
because I'm thinking of the playground by Central, that's residential, so that wouldn't be included in this, this section, correct?
Right.
Yeah.
So, go
So,
ahead.
so if you look at this diagram of corner side yards, I mean, it might not be in what you guys have, but,
It's in the packet.
okay, you'll see.
I'm looking at it right now.
If you have a swing set
Yeah.
up right against the intersection of the sidewalks, that's just odd, whereas if you look at the lot next to it, you can see if it's back behind the house in an actual regular side yard, it's more appropriately placed.
Okay, that's fine. I don't feel strongly about it.
So at the beginning of this, so 1073A7B has maximum wall height, maximum building height for B1. C for B2 only says structure shall be limited to 15 feet. This is our current code. 15 feet of what? How would staff interpret that? Is it the wall height, maximum building height? Or we
Well,
could deal with this later when we're done with TOD.
I mean, it's a good question. If someone were to install a garage, are you looking at the wall height or to the pitch of that roof is 15 feet? Is that, I don't know how tall your playground equipment is, but is that something that would exceed that height from the grade to the top of whatever that structure is? It's likely probably some type of garage, I would imagine, would end up being in a B2, but there's certainly other types of accessory structures that could be considered. And so the more specific, guidance in the 107-3A-7B about B1 offers a little bit more guidance about what wall height versus to the full height of whatever that accessory is.
Well, since your office deals with permits, do you want that more specified for B2? Or is it fine?
I mean, I guess it's a blanket, kind of a blanket statement, and I'm trying to think if there's anything in here that would be both temporary or, well, it's not temporary, it's accessory. So, sorry, I'm just considering. So I think it's fine, we can bring this back if there's anything specific. You know, something like solar energy systems, it depends on what that is. If someone were to propose placement that would exceed that 15 feet in height, I'm not sure of the application for that, but just thinking creatively or at what this could be, additional guidance could be helpful. So.
Yeah, in the absence of anything else, I mean, I think you read the 15 feet as maximum building height,
Right.
so,
Just seemed odd compared to the B1 description,
sure.
but again, not related to TOD. So then back to the exceptions in the corner side yards. If permanent and temporary are adequately specified, are we okay with these?
Yes. Yes.
Well, why not allow permanent outdoor seating in a corner side yard? I mean, what would be the problem with that? For instance, you have a business or restaurant, and they're on a corner, which they often would be. Why not allow permanent outdoor seating? It couldn't be a safety, I mean, it could be a safety issue, but people can sit, particularly adults, right?
Because we allow temporary outdoor seating?
Yes, so that's not it's clearly not a safety issue. Is it that it's concerned that you'd have a structure, a substantial structure, and seating shouldn't be structural? But even if you imagine it structural, like, concrete chessboards and seats, I don't think that's objectionable necessarily.
Can you show me that diagram, please?
Shoot.
Putting you on the spot. I can't find it in mine.
Here it is.
So your interpretation in the business districts, the corner side yard, I can't really read it, is that this one?
It's hard to read. That says front yard. This says corner side yard.
Yeah, but it's still the street.
Yeah.
So if we take the definition of permanent seating as something that is affixed to the ground, can you think of a reason why the consultants would not allow that in the corner side yard? Or aside from why they did it, do you want to allow it? Is that what your suggestion?
It appears, if I may interpret what the consultant did, is they did not support any kind of permanent element in the front yard or the corner side yard. That was kind of their guiding line. You can put permanent seating in interior side yards, you can put it in the rear yard, but you cannot put something permanent in along the street. That's where it seems to, that's where their line appears to have been. You can have temporary seating, so something that's movable, which is what Labara does. They have what would be defined as temporary seating on the corner. That's acceptable. We just don't want, let's pick on Labara, because we can. We just don't want them building concrete things there.
What about a park bench that's adhered to that's bolted to the ground? That would be permanent. So that
That's
wouldn't
the
be allowed.
village. I think, but when we're talking about for a business, they're doing large scale, multiple, many seats, public gatherings. That's what I'm
You
imagining the
could,
consultant.
but it could not be that too. I mean, you could have, a tasty freeze, and they have a couple park benches bolted to the ground. That would be permanent seating, that wouldn't be allowed. Now, that's not gonna be the end of the world, they could just unbolt it, but I don't know, I'm just thinking if there's a good reason to not allow it. Maybe we could make it a special use. Of course, then someone has to go through the cost and expense of applying for a special use.
I do think it makes sense to not allow permanent structures in the street yard. Because
That-
businesses could get very creative about what they're
And I think that fits
calling
with,
permanent seating,
sure,
and
yes.
it would be hard to.
I think that fits with some of the other discussions we've had, whereas we'll let you have some seating there for temporary use during nice seasons, but then end of the season, time to clean it up and reopen the area.
So what is the philosophical reason to not allow something permanent in a business district's corner side yard? We just had the discussion about the need for rolling green lawns in Riverside in the residential area. But it's paved, let's say it's a paved corner side yard, why not allow permanent, small
I think-
structure in it on a paved?
To Commissioner Peltier's is people get creative. And the danger is that we go from a seat and a bench thing that then becomes, there's something attached to the back of it that's equally,
Well, then you have to have definitions, right? So we define.
Or we
permanent-
just say
We define structure.
you have to be able to
permanent
move it
facility.
out of the way. And that gets rid of the whole problem.
But also limits perhaps the ability for a business to be creative and attractive and fetching to customers.
They figured out ways in the pandemic to develop enclosed seating areas that were temporary, and they then go away at
Was
the end of
that
the year.
especially allowed? I don't know what the history behind that was, if it was like special.
It depended on the city, I
flexibility.
believe.
The only thing I can come up with from just an operational standpoint as to why we may not find it desirable is that when you think about temporary uses of corners in a business district, one is for a visibility standpoint of persons passing from one corner to the other, crossing a street perhaps. And so reducing the kind of permanent structures, like if you were to create a tent or some other fixture that would be permanently fixed to a location, may create just a visibility issue. The other thing would be, for instances, like snow plowing maybe, and street clearing, snow clearing, and those types of things, and having permanent fixed allowances may inhibit the ability to continue that flow of pedestrian and vehicle traffic with snow removal in our particular climate. So it's just a couple of things I can think of just from, like I said, operationally as to reasons why we may find it desirable to have them not permanent, but allow them in certain circumstances.
And maybe we just want to be careful about what we call permanent and temporary. You know, maybe a bench that is
Perhaps.
bolted to the sidewalk is, to some extent, temporary, because it can be moved, or, you know,
Yeah.
wouldn't be considered permanent because it's fairly easily moved.
Another consideration, I'm just throwing this out here for consideration, is the concept of, as it says in here, limited encroachments are allowed up to a certain buffer area or 5 feet or something. That could be
Yep.
allowed potentially in a corner side yard. Permanent seating, as long as it's not within 5 feet of the property line, or something like that. Those are creative ways, I think, that could be considered to also give businesses more flexibility in what they can do on their own property.
Well, is this an issue that maybe we just want to seek clarification from the consultant as to their
Sure.
reasoning?
And maybe open it up at a public hearing, and
Yep.
just say this is something that's undecided, and what do
Yeah.
people think?
Yep.
I will include them in the conversation.
I had 2 comments on the 10-7-3 fence standards. If we're ready. So the first one is in existing text. It's subparagraph 3, fence and wall height. I think it could be a weakness to say the height of all fences and walls shall be measured from the ground to the highest point of the fence. I'm wondering if it would be tighter to have grade or average grade within 5 feet of the fence or something like that to avoid people perhaps boosting up the ground a little bit where they put their fence and then putting the fence on top of it. That's a suggestion. I think there is a definition for grade in the existing code, maybe referencing.
Last month, I think we talked about grade being defined as the street immediately in the nearest point on the street.
Right, I don't know, yeah, how that would work, if you had I was envisioning that, well, in the business district, which is pretty flat, I don't know if there'd have an issue with defining the street as the grade if you have some of the areas in residential areas, there's a bit of sloping up to the lawns and things like that. That would have to be considered.
We could use street, we could use the top of the curb. Those are things that the village controls because the village does the work on them. That's not going to change in any appreciable way.
Well, the fence and wall height is applying to both residential and business districts. So I would just say maybe look at the definition of grade in the existing code, or else have something like an average of the ground level at within 5 feet of the fence, so that people cannot change
Get
the grade
creative.
and then put a fence on top of the grade.
The current definition of grade is the average level of the finished surface of the ground adjacent to the exterior walls of the building.
I think the issue becomes adjacent. Is it the 2 inches right next to the wall, or is it out to 10 feet?
Yeah. I think it should be expanded to.
We
maybe
need
5
something a
feet on
little
either side
more.
Or something.
You could pick the sidewalk. Again, that's public right of way, so it's not something that the property owner can manipulate in a,
Right, but what if the fence is in the rear of the property?
Yeah, a backyard.
300 yards away, or?
Someone
I
changes the
believe
grade
that
of their
the
backyard
sign-
and then puts a fence up.
there was language in the sign code that took that into account. I think it had a mention of 75 feet, but somebody needs to check my memory.
Well, we didn't like what was in there, so we're,
But I think if we're,
Changing
we should be consistent with that. That way we're consistent across all of our rules. Whatever we decide there, I would apply here as well.
I would just be
I
worried
think that
about,
would-
yeah, I'm just not sure, it would be for a professional, again, beyond my knowledge, to decide if street level is appropriate when you're talking about a fence in a residential backyard. Especially, as I said, with some lots naturally, or for 100 years, having been raised up and at a higher level than the
That's a
street.
good point,
A
too.
lot of the streets are sunk in Riverside, so I would be more tending to go towards that, say 5 foot on either grade, 5 foot, grade at 5 feet,
Measured
an average,
perpendicular, yeah.
right, something like that.
So it sounds like this is another question for the consultant to address?
Or maybe our staff, because we already have something in our code, maybe a suggestion as to what the best thing to do is.
Yeah, certainly, we'll ask the consultant, and we could even take a look at, pretty much everybody has a fence code, and if
Yeah.
there's something that more acutely defines how we want to look at it or measure it, then we'll bring that for consideration.
And then I had one suggestion at the at the end of page 17, there's a red line. It says fences and walls that, I'm sorry, it's right above, before the red line. So again, it's in the existing text, but it references, you can have an 8-foot fence if you're abutting a railroad right-of-way. And I'm just wondering if we should also include public alleys there, if you're abutting a public alley or a railroad right-of-way. It's just a suggestion.
Can you repeat that suggestion? What did you, I didn't hear you.
Yes, so it says that where a lot within a business district is adjacent to a railroad right-of-way, the fence can be up to 8 feet tall. And I'm just wondering if we should have a similar allowance if you're abutting a public alley, which is like a right-of-way for a railroad. I don't know what people think of that.
What is our current restriction with regard to fences
6
along
feet.
6 feet? And are you suggesting that it should be 8 feet even in residential areas or just in business areas?
A residential area, if it abutted a public alley,
Mhm.
like we have a lot of houses, where that is the case. And maybe people don't agree with that, I don't know. It just seems to me like a railroad right-of-way is similar to a public alley right-of-way, and, if the issue is privacy allowing 8 feet, then why not do that for a public alley?
I'm visualizing a property that borders a railroad, and I know that I'm visualizing the train being elevated to begin with, which would necessitate the 8 feet. I don't
Yeah.
know if an alley would necessarily necessitate 8 feet. I think 6, you've got cars and you've got people going down an alley, and I think 6 feet probably, my opinion is that 6 feet sufficient for alleys. 8 feet, I think that they're considering the fact that train tracks are somewhat elevated to begin with.
So for visually blocking the train tracks?
That's what I'm thinking.
Okay, that's fine with me, I don't. It's fine. Please.
I had, on page 17 and 2A, that last sentence, one of the quirks of the village's zoning code is that business districts have front yards and residential areas have street yards. So that sentence is specific to business districts, so it does not need to mention street yards.
Okay.
So take out or street yards from
Yep.
that.
Okay.
Good catch. Back to the railroad right-of-way. It's hard to say. The added text, the suggested text, how does everybody interpret that? So what walls are going to be in business district? They mean the principal structure walls? I don't think so, because they have to be higher than 6 feet.
I am-
Garden walls or?
That's what I imagined, like a courtyard wall.
Do you interpret that sentence as applying to just when adjacent to a railroad right-of-way, or throughout the district?
Throughout the district.
Throughout the district.
So then maybe we should put that sentence first in C?
Yeah.
But then the last sentence is what gets me. If I were working in your office and I saw a landscape berm could be used with approval by the village board, what does that mean? What are the standards? What's required here? What are your thoughts on that?
I was also questioning what characteristics the berm would be allowed or how much space that would take in order to appropriately shield at the same level as some type of fence or screening. I'm trying to think if there would be a rationale that might be based on preservation ideals, if there's an idea where there would be these rolling kind of landscaped areas that leaving that option open rather than inserting a fence there would be appropriate. I, like you said, am not certain as to, like I said, the characteristics or requirements of such a berm, but can talk further about that. You know, I would imagine if something like that is being proposed, it may be in a conjunction with some other type of project, either a planned use or a special use or some other reason or rationale. I don't know if there's an example, a historical example of other projects that we would have pulled from to think that that would be appropriate. I don't know if past reviews have included some type of berm. You know, I would have to find out by other staff if there was such a memory.
Are fences required in certain areas?
Yeah, so you would want to see some type of screening between a business district and a residential district when they abut.
So it seems like this sentence should be separate from C. I'm not sure what its relationship is with C.
Yep.
It seems to me all three of those sentences should be broken out. So you'd have old C, you'd have a new one, which is what Chairman Mateo was talking about, and then you'd have this landscape berm one separate. Although I don't even know if you need this landscape berm.
Well, the
Sentence.
landscape berm,
Trees.
I mean, it should not be in there without any standards,
Yeah.
to your point. I mean, the village,
Right.
Maybe we should keep
legally, the
landscaping
board has to
section.
have some basis on which to make a decision, so.
What it seems to be saying, though, is that we are requiring fences for screening. And you can use a berm for that purpose.
Right, I suppose that's just it. If there is some type of, planting area plus a significant clump of trees and plantings that would screen between the properties or the districts, that may be appropriate. But again, it would depend on what those requirements would be. If it's specified to say in detail, that there shouldn't be space visible after so many years of growth of that landscaping or whatever the type is, you'd have to kind of account for that. Are they responsible for replacing landscaping that erodes that screening? I would imagine so. We'd want that to encourage replacement of anything that would die.
But I don't think this does require that you have a fence. It says if you have a fence or a wall, it shall have a maximum height of 6 feet. It's not requiring people to put in fences and walls.
Well, it's saying fences and walls shall have a maximum height of 6 feet to screen in order to, so I
Right.
feel like we should have
It doesn't
8
seem like a
feet.
well-written
Yeah.
sentence at all. It's a stupid sentence.
We should have a maximum of 8 feet along the railroad, a maximum of 6 feet. perhaps
Everywhere else,
elsewhere,
yes.
Right?
Yeah.
And then if we want to require that a fence be placed for screening purposes, make that statement as well.
Okay.
Which it is sometimes like for drive-ins and stuff like that. That's a requirement. But I think that sentence, I don't know that it serves a purpose here, other than just to say your maximum height, if you do have a fence, is 6 feet. If that's not said anywhere else. I mean, in the first paragraph, it says that. Is that just for
Does.
residential districts, maybe?
Yeah, I think.
Yeah, I think
maybe
the
it's just for
inclusion
residential.
is just because it was specific, the code is very specific to residential districts and not to the business, so adding that in allows us that specific code provision.
So maybe rewriting C to say something like, in business districts, the maximum height of a fence shall be 6 feet, except that where you are adjacent to a railroad right-of-way, it may be 8 feet, something like that. And then take out the berm reference.
Okay.
But you're suggesting adding a D, if there isn't one, specifying when screening and fencing are required. Right? Is that what I heard?
I would think that the landscape berm would only come into play when you're talking about a required fence.
Yes, and I'm not sure I don't think it's a D. I think this needs to be rewritten if we're going to require a fence between, or some kind of barrier between a residential property and a business property, then we need to explicitly say that and not bury it in a conversation about fence and wall height. If we want this, then it needs to be very explicit. And yes, you, Miss Business Owner, must provide this screening device, whether it be a wall that's 6 feet high, a fence that's 6 feet high, or impermeable landscaping.
Is there that requirement in, say, in the
I
business
don't know,
standards somewhere
but
that you must have a fence?
If we're gonna, it needs to be its own element of requirement,
Well,
not,
Well,
So Assistant Manager Monroe, somewhere in here in our code, it says that there needs to be a fence between business and residential district.
Correct. So in past zoning case heard either earlier this year or in the prior, we referenced a specific code element. It may be just beyond what's included in here with the changes that specifies that
I
requirement.
think it was for the Harlem special use. or-
Yeah, the case at 2710 South Harlem.
Right. So that's already in there, and then talk about 8 foot, 6 foot, take out the berm, right? Somebody can apply for a variation if they want to use a berm for
Okay.
fencing.
Okay.
I mean, if you did want to make it easier to use a berm, we could just add some phrasing after approved by the village board, where deemed to be an acceptable alternative at that location or something. Just, we need something for them to grasp onto. So I don't know, if you, in order to not make people go through the variation process, if you want to consider that. Because I imagine the reason they added berm is because it's natural and that's part of what they're intending here. And there is a definition of berm in the code already. An earthen mound designed to provide visual interest on a site, screen undesirable views, reduce noise, or fulfill such other purposes.
And from staff's perspective, separating residential and business district, does that berm fulfill that purpose?
I would say yes, with the caution that we need to be mindful of what makes up that berm, right? We would have to, I don't know if it takes away in from the village forester in determining what is, natural landscape versus overgrowth that shouldn't be there.
Right.
And someone arguing that that's a natural berm, that it could be a landscaped area that is either naturally occurring or purposefully installed. I suppose having a careful crafting of the language to help make sure that it's not just a mess of weeds between a property that someone would argue for.
Right. And the other aspect, so when landscaping is used for screening, like, one common way to do it is with arborvitaes, but I don't know that in Riverside that's an appropriate planting use. That, I don't think we encourage walls of arborvitaes.
Right.
not in the street yard, that's for sure.
Yeah. So, is it easier just to take out the berm reference then?
I think so.
Back to, okay.
Yeah.
Back to chairperson's original suggestion.
Okay. It's all good discussion. So. Okay. What else here? Anything related to the temporary membrane structures, so the tents, storage canopies.
So a temporary membrane structure is an air-inflated, air-supported, cable or frame-covered structure or temporary structure, enclosure or shelter constructed of fabric or pliable material and not otherwise defined as a temporary storage tent or canopy. So our restaurants that have outdoor eating areas and have put up plastic walls, is that a temporary membrane structure?
Based on the definition of that, I would agree.
And are they in fact temporary? I don't remember.
Well, and this would prevent them, because they must be more than 200 square feet. So maybe we don't like that 200 square feet limit, square foot.
Did we determine that we don't have a definition anywhere for temporary? Is that something that we decided that we need?
I don't think we have a definition for temporary, but I think we probably have a definition for temporary membrane structure.
Right.
Okay.
So if those plastic walls are permanent, then this doesn't apply, the size limits. I'm just wanting to make sure that our outdoor dining areas are going to be conforming. If these go through.
I mean, I would guess they're not. I mean, do we have permanent membrane structures?
Right, I think I remember when this was added to the code, it was a suggestion of a contract code enforcement officer that the village was using at the time who had encountered some of these and was familiar with them from other communities too, where people are putting up in lieu of like a garage or whatever, these structures that provide some cover. And it was her suggestion, and the Plan Commission and board took it up at the time to, to limit the location of these and provide some regulation of them. So I don't know that they were intended to cover tents on business properties, for instance, although I guess we'd have to look at closely at the definition and determine whether those fit within it.
Would it be possible to go back to those definitions that were originally considered and make sure that we understand that we are not trying to take away the business tenting and awning that's already in place and in use and seems to be satisfactory to everyone versus our restrictions on temporary membrane structures?
Others may know the history of the allowance for the dining and exterior tent, dining structures. I would imagine they had been through some type of village board approvals, either by agreement or for development agreement or by a special use or something that would have allowed them to construct those in the first place.
Sure.
In which case, they could make those conditions to allow it.
Yeah, so
regardless
specific
of the
to
code.
Labara and Choo Choo, both those are
Yes.
board-approved
No,
areas.
I know they are, but I don't want us to inadvertently, in our review of what is temporary and what's not, to somehow make them non-conforming.
I agree. We don't want to do that.
Right, and it seems to me that the square footage limitation here would.
I think I would start there with what if we approved, what is the board approved, what have we deemed acceptable? And then we can move on from there in terms of temporary membrane structures.
So would it work to add a sentence specifically excluding those type of
It
business
might
structures
be.
just to this?
It might be that easy. I'm concerned that I might not be thinking very well at this point, and so I don't want to inadvertently make them non-conforming.
How would you do what you're suggesting, Attorney Mars, eliminate them or not cover them? Reference.
I'd go back to the permissions that were given in the first place.
Right. This
Start there
And
and
then
then,
put
this
that language in
subsection-
here,
yeah.
you're saying?
this subsection excludes, outdoor dining, canopies, tents, et cetera,
permitted under XYZ, but we also, if there's another restaurant that comes into town and wants to do something similar.
Yeah,
then we-
I wouldn't call out the specific approvals, but approved by the village board.
Yeah, that's where I'm going, but just, we need to have that carve out.
Yeah, I think defining it by use makes sense, though. Right? Is this, I mean, this is intended to kind of control storage structures.
Yep.
Exactly.
So maybe canopies should be removed, or is it temporary membrane structures and canopies specifically for storage?
I
Is
think-
what we're controlling here and then somewhere else.
But I'm like,
I
what
think
about a
there-
sidewalk sale, or,
That's not really storage.
I know, and that's why I'm saying this idea of canopies and awnings,
Yeah.
sorry, tents.
Well, canopies are open. They're not closed, they don't have sidewalls under our definition. I think this doesn't, a temporary membrane structure, I think would include the type of enclosures that they have at La Barra and Choo Choo. And then going back to 10.7.3A7, we were talking about accessory structures and exceptions. A temporary membrane structure, okay, so it's very, so
I would,
exceptions,
yeah, and I think I would rather if staff and
yeah.
Attorney Morris could look at this and bring us to a better conclusion than we're getting to right here.
Because in D10 there, it references temporary membrane structures not allowed in the corner side yard, which I think are what those are.
But La Barra is entirely front yard and corner side
Is
yard.
that front, I don't know what's their front yard and what's their corner side.
Yeah.
So anyway,
It
but.
doesn't-
One of them.
I
They're
think
the-
staff will get this.
Okay, good. Figured.
So, not to belabor this, in the use table, encroachment, type of encroachments table and where yards can be encroached, permanent outdoor dining is listed, but temporary outdoor dining isn't listed explicitly. Does it matter?
I mean, temporary outdoor dining is typically approved by the board for specific locations, so that may be the reason.
Okay.
They're considered special uses, temporary outdoor dining.
Yeah, it's a type of temporary use under the zoning code, so there's ones that can be administratively approved, and then there's kind of a catch-all.
For outdoor cafes.
You're right, there's an
and
outdoor cafe
which
section.
explicitly require their approval.
Anything else? Landscaping and screening?
Landscaping and screening. Highlighting the sustainable design. So integrating best practices for public rights-of-way, parkways, buffer yards, parking lots, and then all of these would adhere to required regulations. We're hitting on some of these things when we're talking about impervious and pervious surfacing, where native planting materials and bioswales and permeable surfaces can all contribute kind of to that inclusion. And so this section adds subsection L about sustainable design, which lists each of these things, citing an interest in protecting stormwater management best practices. And so that language has been added, and then there's also additionally about pedestrian walkways and talking about ground cover and shrubs and softening parking lot surroundings with plantings.
I had a question about that one. So on the PDF, it's page 31 of the hard copy memo. It's page 24. What does it mean? So you have a parking lot and you have landscaping that's already required. Now they're saying if you have a walkway next to it, you need to landscape that? I've struggled with this one, even before the 3-hour meeting.
So say there's just a parking lot, right? And then you have, I suppose that's just it. If you have a sidewalk and you are creating a parking lot from scratch, perhaps, rather than having just the parking lot surfacing plus a sidewalk, you'd end up adding additional buffering of plantings to, that's the only thing I can come up with, because we do have buffering
Right.
landscape requirements. Let me see here.
Anybody else want to take a
We
stab
have
on this one?
we have buffer landscape requirements along public sidewalks. Right?
I have to go back to the code to take a
Not
look at this.
along necessarily interior sidewalks. So is that what this is requiring? That if you have a perimeter sidewalk on a parking lot, like in front of your building, are you going to, is this requiring planting?
Perhaps that is the answer, that if you, that's the only thing that would make any sense, to be perfectly honest. That interior walkway from the lot to the building that's not adjacent to public right-of-way also requires something green.
Yeah.
So I don't think adding parentheses C to perimeter lots or stuff against the right-of-way, I don't think that's helpful, because we've already got those requirements.
And maybe this is one we can shoot to the consultant as well.
Sure. Yeah. Okay, I lost my, okay.
Nonconformities?
Nonconformities. So what they touched here with the steering committee is related to residential driveway standards, clarifying that instead of saying just plain residential driveways, it specifies existing residential driveways located directly on a side lot line, in violation of the required side lot line setback, which is about a foot, shall be considered a legal non-conforming use. So existing driveways can remain there. And then section D of that 10.10.7 specifies that existing residential driveways wider than permitted by the zoning ordinance may be reconstructed to a width equal to or less than the original width. So there wouldn't be an expansion of a replacement driveway. And this just puts it into writing.
Any issues?
No.
Okay.
Definitions section, just added definitions. I added the attachment to the packet as an addition. And so many of these terms we have already talked about earlier this evening.
I had one suggestion on that in the definition for co-working space. Let me just find it.
Is it the live workspace?
It's the co-working space, but it's also there was also another thing I had for co-working.
That's on page
live-
139 of the memo, page 45 of the PDF.
sorry.
This,
My eyes are, I wish there's more light in here. So it starts out, co-working space definition, a structure comprised of communal and private workspaces in a shared office environment. So my suggestion is just saying a structure is, could not be accurate. It could be part of a building. It could be, you know, a floor in a building. So just clarifying that. It doesn't have to be a standalone structure.
So instead of a structure, could be space comprised.
Yes, whatever, like the office definition, similar to the office definition.
Okay.
Which is, which references a use, I think, not structure.
Okay.
Unfortunately, I had a couple notes way back on page 28 of the PDF.
Page 28 of the PDF.
28?
27 and 28, the encroachment table. So one, and I'll just give these to Ashley to pass along, are just more references to street
Very good.
yards in the business districts. But on 28, I was concerned this, the section on permanent outdoor storage for business uses. It ends by saying all proposed outdoor storage facilities shall be subject, adjacent to residential districts shall be subject to design review approval. And I don't think we have any kind of process that would be a design review approval. So I'm not sure what they mean by that or how we would do that when someone requested it. Whose approval and under what standard?
So 2 rows down in planter boxes, it says, subject to appropriate village review and approval.
Right,
Okay.
right.
Is that
That's
acceptable?
a little bit
Still
the
vague.
same, yeah.
But it's
Yeah.
not assuming a formal process,
Right, right.
to me.
So it's better.
So left to my own devices, if there was to be no change here, but, you know, to allow for village approval and review, when looking at design of whatever this may be, you know, I would probably go to something like enclosure requirements, materials requirements. So if there were exterior materials allowed in town, whatever those types of storage requirements might be, would probably be the first step in assessing whether whatever's proposed is appropriate. Although it's one of those things where is a permanent outdoor storage considered propane tank enclosures? And, you know, is that something that is appropriate based on the business use? Or is that outdoor storage subject to village's approval for how those can be stored?
Right.
You know, that would be a question I'd have. You know,
I
we do our
mean,
best.
the problem is under case law, if we can't point to something that staff based its decision on, then it's completely subjective, and if we deny it, we're gonna lose. It would be found to be too vague, et cetera. So, you know, those things you're saying are good, but we need to kind of call them out somehow.
Sure.
And the same for appropriate village review and approval, but that needs something more to it. So,
Okay.
all right.
Thank you.
Thanks for going back.
Since we did go back,
Uh-oh.
I was going to let this go, but I'm going to put in my pitch for freestanding permanent planter boxes being allowed in front yards in residential districts, or at least within a certain number of feet of the primary principal building. I don't
Okay.
think that's unreasonable. I know we might not want a planter box up by the sidewalk, but
Well, we don't
That's my
allow
suggestion.
hardscape, at least in the
we allow
public right
patios,
away.
don't we? Don't we allow patios in front yards?
I don't think so.
I
But
don't
we allow
think so.
porches.
I don't think so. I do think so. I think we allow patios.
Okay. Well, sure, I've seen some, yeah.
You could,
So I don't know, I just think it's reasonable. Not that I want to put a planter box in my front yard or notice, as I drive around, I don't notice a lot of people having them, but I think it's,
Right, well, I guess when I think of my own house, I got the stone, the big stone ovals, and then
Right.
there's a 100-year-old box at the base of the stoop. You know.
which are not building mounted, which is allowed. So I don't
Oh,
know.
it says building mounted?
Well, it is allowed if it's building mounted, yes. Freestanding, not allowed in residential districts in the street yard or corner side yard. And I would just put in a pitch for allowing that within maybe, I don't know, 10 feet of a house or
We might want to
25% of a street yard. Or
we could try and do it here, or we can revisit it.
we could.
I'm,
I do
There-
think we should have time limits.
All right, let's move on.
Just for our own functionality.
and it's not that I'm opposed to the idea, that's another
No, let's stop talking
fascinating
about it.
landscaping and
We can
discussion.
stop talking about it. That's good.
okay. So the last piece of this conversation tonight is an inclusion of the appendices. So they've updated and refreshed some maps, some diagrams, and if you have comments on the way that those are presented, then certainly bring those to attention.
I had a question, special use standards, it sounded like it said that they were changed. I didn't notice that in the red line document, any changes in whatever that is, Appendix H or whatever.
It may not include the changing of each of these exhibits. There were a couple of different maps, and I pulled out the whole appendices with a change. But it said it changed the
They were
special
listed
use.
in green by the consultant in the most recent round,
Sorry about that.
and maybe
No,
I think I looked it up on the laptop before I came here, and I didn't notice the change.
if they said
So
they
that's just
made a
a
change,
question.
then we can, I ran into that when I was talking with the consultant and asked about that. There was something they said they had changed, and it was not. And so therefore, I didn't include it in my information, but their memo may still have it.
Okay.
So, sorry about any confusion regarding that. My intent was to remove that.
Yeah, I think what I'm talking about is in their March memo that was on the Todd Steering Committee webpage or whatever. In
Yes.
green, yeah, so,
Okay,
okay.
thank you. I'll ask them about that. I'll double check.
Yeah, it's just red lines, as if something was edited, but I don't know what the change was.
Yeah.
Anything else? Excellent work.
Thank you for
Everybody, but
everyone's
especially-
work. You have taken a lot of effort to walk through each of these things, and it's good conversation. I think we'll be able to bring things back for you next meeting to hopefully be decisive on some things and further discussion on others. So, very good.
Do you need feedback from us before you all talk about what to put into the public hearing?
I think we need to determine based on what we can make changes to without having further conversation about what's to come and whether those things would impact how you would discuss items in the next meeting. Right? Am I saying that right, Michael?
I think so. So for instance, if we did a public hearing on the sign code changes in April and then brought back an updated draft of this section for everybody to look at and see if we're all comfortable with the way things have been changed and worded before we go to public hearing on that might be manageable, for instance, for the April meeting. Is that something like that? Because based on the number of changes to this tonight,
Yeah.
I don't know if you want to jump straight to a public hearing, because I think there's, might be further tweaking.
That makes sense.
Okay.
Does that work for you?
We will continue to push ahead and do as much as we can within reason that everybody's comfortable, and it'll also allows for adequate review by the public and, before we make it so.
Next on the agenda is continuation of pervious and impervious surface discussion. Since it's after 10. And we were awaiting some materials for that discussion. I propose that we table that. Anybody
Fully
opposed?
support that statement.
Okay, then, our next meeting is April 27th. If you know you're not going to be available, please let us know. With that, do I have a motion to adjourn?
So moved.
I second.
I can do all in favor. All in favor?
Aye.
Any opposed? All right. Thanks, John. Good night, everybody. Motion passes.